But joining us now to discuss this hour in Florida, criminal defense attorney and former prosecutor Brian Silber, and in New York, criminal defense attorney and attorney Rachel Kugel. Rachel, thanks so much for being here. Brian, you too. Brian, let me start with you. Listening to this testimony of this then 8-year-old, now 11-year-old, testifying about his beloved sister, the one he was the closest to. They were both there for this sleepover. And the prosecution's case is that Briasia was removed from this home and was shot and killed at a different location 20 miles away. And everything in the background of the case suggested that this little boy was not there, but now he's testifying that he was there. Is this going to confuse the jury?
Well, my understanding is he's having trial in front of a judge who will very professionally know how to dissect the evidence. But absolutely, when you have a witness who has problems like this, it speaks to their credibility. Not to mention the fact he would have made these observations when he was 8 years old. And for purposes of a criminal trial, which remember is the highest level of evidence we need, I don't believe that an 8-year-old is reliable. You know, an 8-year-old can testify about generalities. But the 8-year-old mind is not a good recorder of information, not a reliable recorder of information. And they're also subject to influence. And there's no doubt that this little girl victim's mother absolutely would have gotten this kid's head. We can't ignore that fact. So no, I don't find his testimony credible. I don't find his testimony believable. But I think there's other reasons why this gentleman will be convicted. And one of them, and this is so superficial, but it means something. What's with the haircut? What are those two things sticking out the side of his head? The man's on trial for his life. He couldn't get a haircut before trial. It just communicates that there's something not right with the gentleman. That's not a fashionable style. I don't know where he got that idea from. It looks ridiculous, and it speaks to his character. You know, just beginning with that, not to mention there's other evidence that I think will convict him.
Brian, first, I'm so glad that you corrected me and reminded me that it's just a judge, not a jury in this case. I think we have video of him actually braiding his hair there inside of the courtroom. Rachel, I want to ask you this. To Brian's point about this being a bench trial, and this was the defendant's request, do you think that it may have been a better idea to have a jury, since something like that may have helped their case, knowing that there was this inconsistent statement from his son?
Yeah, so it's a really rare thing for a criminal defense attorney to waive a jury, right? Because most of the time we want that jury. We want 12 regular people, you know, theoretically our client's peers, to be able to hear all the evidence and hold the state to their standard. I think, though, what you're seeing with this child witness may be part of the reason they made the choice in this case. You know, where you have a guy maybe who isn't so likable, maybe who does present a little strange, you know, maybe in this instance you've got, you know, a child witness who, you know, maybe they thought that this child witness would be empathetic or, you know, pull on the heartstrings of a jury potentially. You know, this is where maybe you do choose a bench trial, because a judge can sort of put those things aside and look to pure law. So if you've got maybe not great facts, you've got, you know, a child victim, a child witness, things of that nature, just these are ticking the boxes in terms of that. You know, those are things that a jury's going to have a hard time kind of getting over, just in terms of the way that's going to tug on their heartstrings, right? And so if you have an interesting issue of law, for example, whether a child witness like this could be really even qualified to give, you know, consistent, believable testimony, that might be one of the reasons they made that choice. And, you know, listening to this child witness testify, I think he certainly is not credible, but you wonder how a jury of regular people, you know, who have their own children perhaps, you know, who see things in a different way than a judge is going to see them, might be pulled by the heartstrings of, you know, this is his sister, this is right. And a judge arguably is not going to be moved by that. And he's just going to look purely at the law, credibility, or at least, you know, right, that's the hope. So I think that what we're seeing is maybe coloring one of the reasons they made the choice they made in this case.
Brian, let me ask you this, because this is a circumstantial case in terms of the evidence that they have. They don't have necessarily a murder weapon. We're going to see what forensics come out in the case. We haven't gotten to that point yet. But what's missing, really, not that the prosecution has to come up with this, but a motive. What caused him to remove this little girl from the home where she was sleeping in with him and take her out to a pond and shoot her in the face. What do you think the difference between a bench trial and a jury trial that will create for this case and for the prosecution getting to beyond a reasonable doubt?
So first of all, remember, the prosecutor does not need to prove a motive. That really is just something that helps jurors understand the bigger picture in a case, because they always want to know the why, the why, the why. But he's not in trial in front of a jury. He's in trial in front of a judge, someone who has seen the craziest things happen out there. You know, you never realize how bizarre human behavior is until you start practicing law. And this judge who presides over criminal cases has seen everything. He's not going to be moved by a lack of motive or the explanation for it. But I got to tell you, the one piece of evidence that I read about, I didn't see it in trial, but I did read about it, was the mom called him about the missing girl, and he said he didn't know what happened, and he was going to go report it down at the police department, but failed to do so. How do you fail to report a missing child unless you have culpability, unless there's a story going on there? You know, that's a major hook of evidence that the defense is not going to be able to overcome. And if I'm the judge, I'm going to have a serious problem with that, because when you have a missing child, it's red alert. You stop what you're doing. You get the neighbors, you call the police, you hit the streets, you do whatever it takes to go find that missing kid. And that's the opposite of what he did.
Absolutely. There was this time period also where police couldn't get in touch with him. They talked to him about 8 or 9 in the morning, and then he didn't show up to the police station like he had promised until noon. He also turned down a polygraph, Rachel. That doesn't come in a court of law, but police still ask. That struck me as curious, that they still ask if he wanted to take a polygraph, and it's still in the court record and the facts of the case that he denied that polygraph. What do you make of that part of this case?
What you're seeing with that is, you know, really investigators doing everything they can because they had a missing child. And, you know, obviously that is the highest level of concern, especially, you know, we want to get to that child quickly. We want to get answers quickly. You know, hopefully, God willing, we're finding that child alive, right? So they're doing everything they can to try to make decisions quickly, rule out people, rule in people, right, as fast as possible. So I think that's why you're seeing that. I don't think that comes into evidence that he refused it or that they offered it, or any, just as a polygraph wouldn't, the results wouldn't come into evidence, right?
Absolutely. Nope. And especially this being a judge, yes, the judge knows about that polygraph because of the pretrial litigation, but wouldn't be taking it into consideration. But up next, we're going to hear from a very important person in this case.
Every possible place to find the daughter that she loves. And you know that she's been shot, and you know where she is. And you let your mom go out and search that way?
I told her where she was.
You told your mom where she was?
Yes.
Right away?
Not right away, but someday after that.
This is a case that's going to start up again in the next hour.